Good evening, folks. I'd like to call to order the Planning Commission meeting of today, November 24th, 2025. Christina, would you please take the roll?
Chair Mitchell.
Here.
Vice Chair Donchak is not here yet. Commissioner Moreno.
Here.
Commissioner Guinea.
Here.
Commissioner Sly.
Here.
Commissioner Tewing.
Here.
And Commissioner Bruce is also absent.
Thank you. Item number 3 on tonight's agenda is the public comment section. The purpose of the public comment is allowed to community members to present information or raise an issue for items not on tonight's agenda. Christina, do we have anyone?
We do. Diane Cassidy.
Hi. Good evening.
I have some handouts for the commission. Who do I give it to?
I think check, is the green thing on the microphone working right in front of you? Green square?
There's a red button. Do I push?
Yeah, push it and then it turns to green.
Actually, I think you can hear me. Okay, my name is Diane Cassidy. I live on Wren Street in Lake Oswego in the Blue Heron neighborhood. I've been a resident of Lake Oswego for about 50 years, and I am I have for the last 25 years been an owner of commercial property, both office and apartment complexes, mostly in the Clackamas County, but some in Washington County also. Currently, I am the owner of, I've sold most and own an office complex in the Tiger Triangle. I'm here today because about this body's position as the Commission for Citizen Involvement. I didn't hear about the Cruz Way proposed zone change until November 5th, when I just happened to pick up a newspaper telling about the public hearing that had already occurred. I would have liked to have been informed of that. I would have liked to have known and testified about that. But unfortunately, Blue Heron isn't on the list of neighboring neighboring communities. I am on the board of directors for the neighborhood association, but again, we were not close enough to be included. This, a zone change with the magnitude of impact that this could have on Lake Oswego should not be considered as a mere as a mere comprehensive map amendment. It has been downsized and minimized to such a degree that citizen involvement has been basically penciled out. It's been minimized to the point where, where just the magnitude of the potential that this could bring doesn't reflect what the comprehensive plan that we all worked so hard for over several years back in 2013. Our efforts are just meaningless, and the plan itself can be just torn up and thrown away if this sort of thing is allowed to happen. This kind of application should be treated as a whole that includes the entire city, because the implications are so broad. It will change the entire nature of the city. With an R0 zone, this one property can accommodate up to, given the applicant's own estimates, from 600 to, and if you change the size of the units, maybe 800 units of housing. But we don't know what their plans are, because this has been separated from a development plan altogether. This is just the map amendment. And so the details and the real full impacts of how it's going to affect Lake Grove, how it's going to affect the citizens, how it's going to affect the entire city, just haven't been examined. The city planning staff has basically given this a rubber stamp as far as compliance. And even the applicant themselves have not told the truth about why they want to do it. They say that the property is not performing well. When I went over there last week and talked to some of the occupants, they said that the landlord has been not renewing leases for quite some time. The place is virtually empty. You cannot empty out a place like that without it taking a couple of years, because that's the way leases are staggered. There has to be some plan in place for them to not be collecting any money, and they must have some kind of confidence that their plan for redevelopment, or at least for a zone change, which will raise the value of the land, will be accepted. That's very troubling to me. It means that they know something that the citizens don't, that the citizens haven't been involved in the planning from the start, as is required by the state.
Ms. Cassidy, if I could cut you off for 1 second,
right.
apologies. I'm supposed to limit it to 3 minutes, but I wanted to say one thing. We have a continuation of that particular hearing on the land use application.
Oh, I did not know that.
And I believe the date is December 8th. Now, what I don't know is if we can, it's still within the time frame to sign up to testify at that hearing. That is closed for testimony.
The record for that hearing was closed. I think the last final written argument for the applicant was due last Monday, and so that record is technically closed.
Yeah, and if the record is closed, I mean, anyone is allowed to provide public comments at any public council meeting or planning commission meeting, but we have to advise you all not to, unfortunately, take into consideration any public comments that you receive after the record's been closed.
Okay.
You have to advise them that what? They can't take into account anything I'm saying here?
Because it's been taken after the record's
All right,
been
well
closed.
then, let's skip to page 2.
Ms. Cassidy, you can testify at the council meeting because this
This is the
matter
December
will go
8th meeting you're talking about? Or
So
no?
the planning commission will make a recommendation to the city council, and unfortunately that record is closed, but you are still able, when the hearing goes to the city council, which I believe is scheduled for February 3rd, you will be able to testify at that
Well,
hearing.
then let me skip to page 2, where I am making a formal complaint to the Commission for Citizen Involvement about the woefully inadequate citizen involvement that has accompanied the zone change request and its reduction to a mere map amendment that further degrades the level of public involvement. This zone quest should be denied outright or at least postponed until the formal evaluation of all zoning in the city has been done. So this is my time to complain about citizen involvement that should have occurred at a much grander scale, and the fact that this was minimized to a mere map amendment when it didn't have to be. And when think of 3 to 4 windward apartment complexes being placed on that one property and how that might impact the area. And the rumors are that there's more being planned, but I can't speak to that. It's just that the citizens are in the dark about what's being planned for their own city, and their comprehensive plan is being ripped to shreds.
Thank you, Ms. Cassidy.
And you're responsible for making sure citizens are involved from the start.
Thank you so much for coming down tonight.
Thank you.
Okay, Christine, I assume nobody else to present items not on tonight's agenda. Okay, got it. Okay, that will take us to item number 4, general updates from the Commission for Citizen Involvement. I have one postcard here for the Evergreen neighborhood folks. The Evergreen Neighborhood Association's Emergency Preparedness Committee is asking the Evergreen neighbors to take a short survey to help determine their readiness and resilience. If you go to the Evergreen Neighborhood Association website, there is a link to the survey, and you may have received flyers, so please do that. And that will take us to item number 5.1 on tonight's agenda. This is a public hearing. We have a public hearing for the home occupation standards The number is LU 25-0002. And I'm going to turn it over to the city attorney to state the meeting procedure to the public.
Thank you, Chair. Now is the time set for the public hearing on home occupation standards LU 25-0002, a development code text amendment. This is a legislative decision, which is generally a policy decision within the discretion of the City Council. The Planning Commission will review the legislative proposal and make a recommendation to the City Council. Although a legislative decision may be discretionary, it must also comply with any applicable state law, as well as any applicable statewide planning goal or administrative rule adopted pursuant to ORS Chapter 197 or 197A. A legislative amendment to the Community Development Code must also comply with any applicable provision of the Lake Oswego Comprehensive Plan. The public hearing process will begin with a presentation by staff. Testimony will then be received from the public. Individuals will be allowed up to 5 minutes. Recognized neighborhood associations, homeowner associations, government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. The time limits, will not include time taken by questions from the commission or responses to such questions. Testimony by attorneys, representatives, and witnesses on behalf of or which are part of the presentation by a person shall be counted within that person's time limit. Any person in attendance may cede his or her time for testimony to another person, but in no case shall any person's testimony be increased to greater than 10 minutes. At this point, does any commissioner wish to declare a potential or actual conflict of interest?
No.
Okay, seeing none, and because this is a legislative hearing, we do not have to declare any ex parte contacts or bias. So the chair will now take the hearing proceedings from here.
Thank you. And I will turn it over to staff. I believe we have Staff Coordinator, Mr. McNamee, will take us through the staff report.
Thank you. And good evening. This is a public hearing regarding a proposed update to the Community Development Code regarding home-based businesses. Tonight, I'll talk the Commission through the proposed changes and staff's recommendation. The city also received written testimony in regard to a proposed limit on the number of customers or clients permitted to visit urban agriculture businesses, so I'll discuss that on the relevant slide. So to start, let's talk about the process so far. The Commission has held 3 work sessions, and City Council has held 2 study sessions. At the Commission's first work session in January, we discussed possible concepts for replacing an existing zoning requirement for home-based businesses, otherwise called home occupations, that is neither clear or objective with measurable, clear standards. After that discussion, staff sent a survey to every home occupation owner licensed with the city to better understand their needs and level of understanding of existing requirements and propose new concepts. The results of the survey were discussed with the Commission in April. As part of the survey and other feedback received, staff identified a potential need to create a new a new agriculture use, which was discussed with the Commission in June, along with refinements to the proposed home occupation code. Out of this process, staff is presenting draft code amendments to the Commission that make the changes listed on the screen regarding home occupations. I'll discuss each of these in more detail in the following slides. Since we've already discussed a lot of these concepts before, I'll keep the discussion higher level, but we can look at the proposed amendments themselves if the Commission has technical questions. So the first change is to remove an existing zoning requirement for home occupations. This is subcriterion 1 in the existing list of use-specific regulations for home-based businesses. It says that a home occupation can't alter the residential character of the neighborhood or infringe on the right of nearby residents to the peaceful enjoyment of the neighborhood. As we've discussed previously, this requirement is vague and subjective, which makes it difficult to understand and enforce the limits of a home occupation. The proposal is to replace this requirement with standards that are more measurable and objective so that everyone understands what is expected of a home-based business. The proposed amendments would create a new classification system for home occupations. The purpose would be to apply additional regulations to types of home occupations that typically have a greater impact on the surrounding neighborhood. There would be 3 types, A, B, and C. Type A businesses would not have customers coming to the site of the business, while Type B businesses may have customers or clients at the site. Type C businesses would be short-term rentals, which already have their own set of additional regulations in the Home Occupation Code. For all home-based businesses, the proposed amendments include a limit on hazardous substances in amounts greater than what would typically be found in a home. Regulations on hazardous substances are not substantially present in city ordinances. Ordinances. I think I mispronounced that twice. It's okay, I'll move on. Since they are primarily regulated at the state or federal levels. This has made it challenging in some circumstances for code enforcement staff to enforce on home businesses that have excessive amounts of hazardous substances. Adding this limit would give them clear code to point to in these situations. Over the course of this process, we've discussed a few ways of potentially regulating noise or other nuisances, which can be a problem with certain home occupations. Oh, I am one slide ahead. I'm sorry. So ultimately, based on feedback from the Commission and code enforcement staff, the proposal is to include new code that would reference existing city ordinances that cover nuisance restrictions. The existing rules should be sufficient to cover potential nuisances created by home-based businesses, and they already apply today. Adding the reference will simply make it clear where the nuisance regulations are to anyone looking for rules specific to home occupations, and serve as a reminder that the rules apply to those businesses. The proposed code would also include a limitation on commercial vehicles parked off the subject property. A home-based business would only be allowed to have 1 vehicle with commercial markings parked off the property within 300 feet of the business at one time. As you might remember from previous discussions, the code is written specifically so that it applies only to vehicles that have clear markings that associate it with the home-based business. That's based on feedback from code enforcement that it would be challenging to enforce on unmarked vehicles. The proposed code would not include any restrictions on the number of marked commercial vehicles allowed on the site of the business, which is based on feedback from City Council. For types of businesses that involve visits from clients or customers, or Type B businesses, the proposed code includes a limitation on the number of clients or customers allowed at one time. Based on feedback from the survey and the Commission, the limit has been set at 8 people at a time. Previously, we've talked about why it's better for code enforcement to regulate the clients and their associated impacts this way. It's much easier for code enforcement to count the number of people present at one time than to keep track of people coming and going over the course of a day, for example. Also for Type B businesses, the proposed amendments include 2 options for how to handle outdoor activity associated with a home occupation. The Planning Commission will be asked to recommend one of these options to City Council. Option 1 would allow for small instructional classes with sizes of 6 people or less. The second option would be to ban outdoor activity entirely, which is consistent with existing internal policy. Under the first option, no more than 2 sessions per day would be allowed and no more than 6 per week. Hours of operation would be limited to between 9 a.m. and 7 p.m., and outdoor classes would not be allowed on Sundays or public holidays. The use of outdoor space for commercial events, rentals, parties, weddings, performances, markets, or other commercial gatherings would not be allowed. Council feedback has resulted in some changes to these requirements since the last time the Commission saw them. The number of clients allowed has been changed from 8 to 6, based on council feedback that 8 people outside at one time would have too much of an impact when done regularly as part of a business. At the work session in June, the Commission instructed staff to remove a proposed restriction on Sunday activity, which was removed before the council study session in October, but the council asked staff to add a restriction on Sundays. Regardless of which option is selected, the code allows home occupation owners to perform tasks outside that don't involve clients or customers. Under state law, daycare and adult care centers are exempt from specific use regulations in residential zones. The proposed amendments would add language to make it clear where to find relevant state law or administrative rules and serve as a reminder that those uses are exempt from the specific use rules for home occupations. Separate from the changes to the specific use regulations for home occupations, the proposed amendments would create a new land use called urban agriculture, which would be permitted in the R10 and R15 residential zones. This is proposed as a result of feedback from the survey that identified this as a unique use with needs and impacts that were different from a typical home occupation. The use would allow for crop production and sales, as well as tastings or serving of food. It would only be allowed on properties over an acre in size, and the agriculture use itself would be limited to 20,000 square feet in size or 35% of the area of the lot, whichever was smaller. There would be a limit on the number of clients or customers permitted at one time, currently proposed to be 10. Hours of operation for tastings and servings could be anytime between 7 a.m. and 8 p.m., and they could happen on a maximum of 45 days per calendar year or slightly less than once per week. The use of motorized equipment would only be permitted between 7 a.m. and 8 p.m. as well. Based on council feedback, amendments that would have allowed farm stands to operate in residential zones were removed. The council felt that the impact of farm stands would have been too great on residential neighborhoods, especially since seasonal stands like Christmas tree sales are allowed as part of the farm stand use. As I mentioned at the beginning of the presentation, we have received written testimony about the number of clients permitted at one time for the proposed urban agriculture use. The owner of a business that would be newly classified as urban agriculture wrote to tell us that because of the way their business operates, their opinion is that they need the limit to be raised to up to 30 people at one time. To provide context to this discussion, staff originally proposed a limit of 30 clients or customers at a time, directly based on feedback from the survey. At the City Council study session in October, they raised concerns that 30 customers at a time could have too large of an impact on residential areas. So after staff received that feedback, we reached out to this business owner to understand if the limit could be lowered without impacting their existing business operations. And after that conversation, staff was of the understanding that a limit of 10 customers would accommodate the needs of their business while being responsive to the council's concerns. However, the testimony provided by the business owner today suggests that this limit may pose an issue for this specific business. The commission can make the choice to adjust this limit if you feel it's appropriate before sending the amendments to council. That being said, staff's recommendation is to send a recommendation of approval to the City Council for these proposed amendments to the Lake Oswego Community Development Code. Assuming the commission comes to a recommendation tonight, this item would come back at your next meeting on December 8th for findings, after which it is tentatively scheduled for a public hearing with the City Council on January 20th, 2026. That concludes my presentation. I'm happy to take any questions.
Thank you, Michael. Really appreciate that. Commissioners, we can ask questions of Mr. McNamee about the report and the findings. I do have a question or two, but I'll defer to my colleagues at first.
I've got a question. Thanks, great presentation. Is there any path forward that would allow a business, let's say we go down come to a decision that limits clients to a certain number of clients. Is there any path forward for waivers to the city for specific events, days, times, activities, things like that, that would expand that cap at a limited duration?
There's nothing in the code as it's written. Certain events might not be considered business activity depending on what they are. Yeah, as it's written right now, we don't have a provision that would allow for that.
I thought I saw somewhere that there is an exception for once a year that they can do that. No,
We allow special events permits. So someone can do a special event of certain types. They're very specific in our code. And so if they were to have those certain types of activity on the site, then they could, but not for regular business activity. There's no waiver for that type of an activity. That's part of the regular business.
You couldn't get a waiver for like 3 months in a row or something?
Michael, am I correct? I know we got one written testimony here. Is that the only written testimony that we received in advance of the hearing?
Yes.
Okay, so we have not received any written testimony. I think there may be speakers that will testify orally here, but we've not received any written testimony like in favor of these laws.
No formal written testimony, no.
Okay. The urban agricultural, like sort of the new use, is there anything in the current code restricting or covering this urban agriculture use right now? Other than the generic blanket statement that we're trying to take away the residential character of the neighborhood?
Sorry.
Is there anything regulating the urban agriculture use as we're now going to propose? It's a new category with findings, but if I'm going to use the winery as the example because that's the one in front of us, is there anything regulating that right now?
Well, it's currently being regulated as a home occupation.
Okay, just based under that one generic blanket statement?
Yes.
Got it. Okay. And in the report on page, I think it's 4, when we're talking about the specific standards for urban agriculture and making them more restrictive, then I think the original proposal was up to 70 calendar days per year and 30 customers, and then afterwards we changed it to 45 and 10.
Yep.
But the report says, based on feedback from existing businesses, staff lowered the allowances to 45 calendar days and 10. What was the feedback from existing businesses?
So perhaps that could have been phrased a little better. So we lowered it based on feedback from council, but we contacted existing, really is one existing business, to get an understanding of whether that would impact their operations.
Yeah, that makes sense. Yeah, I was trying to see if, was there a consensus among existing businesses that were in favor of this and wanted it lower, and got it. That's what I was trying to get at. Okay. Thank you. Those are my questions.
And I also I am realizing that I left something out of that slide, which is urban agriculture would be permitted as a conditional use. So that's kind of an important detail. And the existing business, or any existing business that would be classified that way would be grandfathered in per the code. So unless I chose to expand.
Commissioners, any other questions about the staff report before we get into testimony? Okay, I think if I have my procedure correct, I think the next one will go up, and I'll ask Christina, has anyone signed up to testify in person or virtually?
Yes, we have first Sam Ho.
Come on up.
Hello.
Hello, thank you for coming down tonight.
Yeah, thanks. Appreciate you guys being here doing work. I just have a couple thoughts. I have 2 registered businesses in Lake Oswego.
I
Sorry.
apologize. Could you just state your name and your address for the
Here's
record?
Sam Hall at 2 Grouse. So I have 2 businesses and a nonprofit that I run out of my home. And there's some considerations I want you guys to think about when you're doing this. I did the survey that when you guys sent it out, I filled stuff out, but it wasn't necessarily friendly enough for all considerations. And that's kind of what I want to put in your brains a little bit. Because I see the need to take away or to bind some businesses in what they're doing from home. I understand that. I understand rules are good. I'm a rule follower. I like them. But I think when you take things away, there's things to consider is what are you offering some of these businesses as you take some of their rights away. And for Lake Oswego, for me, having businesses here, I don't see any privileges given to the businesses that are registered in Lake Oswego as you're taking things away from them, such as I have no market privileges to get my business in this market. And there are a lot of people that come here on the weekends not from here. I have lived here for over 6 years. I have called every year. I can't get in. There's no space for me, but there's people driving 30, 40 miles to come in here and sell their stuff. So if you're going to start binding people, you might want to start claiming some space and just hold it for people that are from here. Likewise, pop-up space in the city. I would love for my business to be in a store. I can't get one. There's not enough storefronts. I'm a seasonal business. My primary business is a holiday business. This is my busiest time of the year. I can't even get my merchandise here, but I'm going to Frankfurt, Germany to Christmas World where they want to see my stuff. But I can't get like Oswego stores to look at it because there's nothing in place to assist me in doing that. Likewise, grants. I'm registered as a minority business here, and I've come in several times because you have great workers that work in this building who are like, oh, you're a minority business. We used to have grants, and we're going to get you some stuff. And I ask them questions, and there's nobody for them to get the answers from. So I look at all that and just want to remind you that as you take things away for those of us who are here, who are trying to build our businesses, be part of the community, find us a path to get out of our homes, because there isn't one. There is no path for me not to work at home. Your marked vehicles ordinance, I think, is great, but you've left it open. Is that a magnet? I have a magnet I can throw on any car I have that makes it a business car. Or is that a permanent marking? Because people can have 6 cars that they're using for business and use the magnets. You're not going to be able to stop them from parking 6 cars. So that's something I think you've missed for consideration. And then agricultural licenses. I'm a little concerned when I hear you start talking about getting into the agricultural limitations, because for my business, I have to have an agricultural license. And I'm afraid you're going to come and start telling me I can't have it where I live because I don't have an acre. But to do flowers, I have to have an agricultural license to buy at the flower market. So don't think that one word agricultural means I'm going to grow a farm, because there's some of us who have to have that license just to even purchase product for clients. So there's things like that I think that the committee should consider, that not only what's the impact and how are we binding, but if we are going to bind people, or how do we get more Lake Oswego people more fluent and more seen in what you're doing? Because I get the work. I get what you're doing. I understand why you're doing it. But I'm nervous that you're going to come and you're going to bind me into a place where I can't have my 3 licenses out of my same home, or I can't do my work because I have to have a license to get materials to do my work, and I'm going to get caught up in something that has nothing to do with me. Any questions? That's all I got for you. I get it, but there's some things you're missing, and I just want to bring that to your attention to think a little further outside the box. But a pop-up space for the city or something would be tremendous. I'm a 7-time Holiday Award-winning designer, and I can't get my stuff seen in this little haven we have here, just so you know. Okay?
Thank you so much for your testimony tonight.
Your time.
Yeah, appreciate it. Okay, Christina, is there anyone else signed up to testify?
Yes. Brian Craig, do you want to add it? No, okay. Diane Cassidy.
I'm Ms. Cassidy.
While I'm here, I know I think I know the winery you are talking about, and having a conversation with the owner last week. I'm concerned that his operation is in jeopardy just because even though there's never been a complaint about the operations on his property, and I'm concerned that bureaucrats sitting in a building and trying to make up some rules don't have the first idea what it takes for every single business to be profitable, to operate, and to know what, I mean, they're all unique. I mean, he's got some unique needs, and I know the winery has some unique needs, and limiting the number of customers at one time or the frequency that people can come to your place, you might as well just, toss his whole endeavor for the last how many decades out the window. That's wrong, and especially since nobody's ever complained. There's been plenty of parking, it doesn't bother anybody, there's no noise. I want to live in a neighborhood that is residential. And if somebody puts out a stand and wants to sell their excess tomatoes, I'm fine with that. I don't know if I'd be so fine with chickens or livestock or a marijuana grow in my neighbor's backyard. So I don't know how any of that sort of stuff is limited, but I just don't know. And I understand the idea of having rules that are objective and fair to everyone and very clear. But this is an area that's it's so unique. It's unique to the individual that you really only can talk about what goes on outside the environment and say, okay, as long as they're not disturbing your neighbor, and maybe you can have a some kind of a code that would allow some things as long as the neighbor is signed off on it. Maybe you have a bad neighbor, but so many within so many feet of your residence, that could say, yeah, we like it, we approve, but grandfather in some of the ones that are existing, and certainly have a place where people like this gentleman can come and explain what their business is all about and how the city can help, not restrict, because this city is so good at restricting things that it's hard. It's hard just, the big thumb of government just needs to let up a while. That's it. And I don't want any chickens next to me.
Thank you, Ms. Cassidy. Appreciate your time.
Okay.
Christina, is that it for testimony? Okay. Okay. I believe that will bring us to closing the public hearing after testimony has been concluded. So the public hearing is now closed, and the Planning Commission will begin its deliberation. There is no public comment permitted during the deliberation process. Commissioners, we can take a vote. We can talk about it. We can ask questions. At some point, we'll need a motion. Who wants to start?
I have a question. Is there a way to, how adult care homes and daycares, they're exempt because of other requirements that they have? Is there a way to write that in for other businesses that come in and apply for a business license if they already have restrictions of some other kind? Like, was it Mr. Hall that was mentioning he's already got certain requirements that he has to meet in order to sell his products or services?
I'm not quite sure if I understand the question, but just to get at that specific comment about the classification of urban agriculture, we have a specific definition of what urban agriculture means in the code, and it doesn't sound like from the description of his business that would qualify as urban agriculture. So I don't anticipate that we are going to find that because he is required to have an agricultural license because of selling flowers and that type of thing, that would then make him be defined as an urban agricultural use. That isn't included in the definition. So I don't see that as being an issue here. But I'm not sure if I quite understood what your question is.
And also, just to add to that, I think perhaps what I was hearing from you as well is you're saying there's additional statutory restrictions or requirements on various types of activity,
Different
corporate
industries.
activity, in different industries, exactly, locally. And so, so for example, you were giving the example of certain types of uses are, we can't restrict and they're outright permitted. Those restrictions are separate from your local development code, and they'll apply outside of the context of your development code, right? So getting statutory permits or licenses, those will always be required regardless of what's in our code, right? So that's a whole different process.
Well, my point is, as opposed to setting more restrictions, to writing in more flexibility for those businesses that are already so regulated.
Yeah, and I guess those requirements that we're referring to are more around how the business operates, at
Right.
least usually, right? Regarding, getting a license, maybe certain ongoing activities to keep that license, whereas these restrictions are regarding their activity and their location within your city limits. And yeah, as much or as little restriction as you want to place on that is up to you all. I think it's just a recommendation that it be clear and objective in order to comply with state law.
Thank you. To speak to just like the idea of the exemption from land use restrictions and citing restrictions for daycare, for instance, that I think you were alluding to, to the extent that we know about those exemptions, we're going to, we typically try to align our code with that. So we do reference that just so local folks that are implementing the code here understand that that state exemption is in place. But, we're not, I think the sort of proposal that you made to make sure that any exemption would continue to apply, I think it was already pointed out that that would be the case, whether or not it's stated in our code or not. If there is a state exemption for a particular business, that would ultimately, not be, sort of preempted by our code, if that makes sense. So, yeah, it's hard to sort of think of all of the different exemptions that could exist. We tried to incorporate that into what we're proposing tonight, but there's no need to have it in our code. It's more for streamlining and consistency reasons.
Right.
So I think this was answered, but just to make sure that I understand fully, businesses would not be grandfathered in. So if you had a permit and you've had a license for years, again, referencing the winery, they just would not have their license renewed when it came up if it didn't meet the criteria. And there's no mechanism to challenge that if we change rules that restrict their use, even though it was conforming for 20 years or whatever the time frame is.
Yeah, that's the reason why we were separating this urban agricultural use out from a home occupation and making it a conditional accessory use to a residential use. That will take care of that so that they still have to get a business license, but they don't have to get a home occupation approval every year.
I think if my memory serves me correct, we've had, I think, three work sessions on this one. I know we've talked about this one, and I feel, and commissioners disagree with me, like we've sort of not, there hasn't been alignment on this one, in my opinion, across the board. And then I think every time we come back after a city council meeting on it, we may even have less alignment based on the direction that city council has been pursuing. So, I'll go out and say it. I'm not in favor of this, and I haven't been from the beginning. I understand the ambiguity around the current code. I understand the concerns from code enforcement on wanting to not have this nebulous concept of residential character. But throughout our work sessions and throughout our hearing, and I just felt like we're just doing way too much for a concern that's not coming from the neighborhood and the citizens of Lake Oswego. And I really haven't felt that's there. And not to diminish code enforcement who, it's obviously the day job to go in there and make sure we're doing that correctly. But I feel like we've sort of pulled numbers out of a hat almost. And it's just too much. I mean, if it were a little more narrowly tailored, maybe, in terms of let's create the 3 categories, or let's make an express reference to the nuisance laws that are already in the city's code. Like, I could be on board with something like that, but this creating a new boundary, having the winery tell us they want 30 when we only had 10, I just feel like we're creating too much, and we're creating restrictions that are going to apply to folks that we never intended it to apply for. So I get city council has said otherwise, and obviously city council are elected officials, and they will make the decision. But I think coming from me, I'm going to not vote on recommending this as it's written, certainly as it's written.
I love that. Will you make a motion?
Well,
So I get
let's make sure.
Because
Let's make
I agree
sure
with
everyone has thoughts. I want to make sure everyone gets it out there.
Yeah.
Yeah, I would second that along the same thing. I think we're creating a bunch of restrictions and not understanding the unintended consequences of the restrictions. And I don't want to tell some small business owner that they can't run the business that they've already been running, that they haven't had complaints about because we arbitrarily made up some numbers or some rules. So again, I agree, we need some more uniformity in the code, but I don't want to overly restrict economic activities and based on criteria and that we don't fully understand how the implications and impacts on some of these small businesses. So I think there should be some rules, but I don't agree with what is written.
Jim, you have a?
Agreed.
Yeah, well said.
And I think staff has done a great job. This is not an indictment on staff, has not hit the points and come back and we've talked about it. I understand staff has to also go in the direction that city council has directed, and I think that's what you all have done. You know, I don't think I've ever had where I felt the commission was going the opposite direction of the way city council feels. So I feel like we might be here.
I appreciate your work on this, but I'm also going to vote against it, against the restrictions.
I think the only thing I'd say is if we do feel maybe there should be some restrictions, do we want to try to think of that? But we've had 3 work sessions and we really haven't, you know, starting from scratch is probably not the way to go. So unless there's any other comments or questions, then somebody can make a motion.
Well, can we agree that creating the, what is it called again? The urban,
Agriculture.
yes, the urban agriculture, I guess, permit, the type,
It's a new use, correct?
it's a new use.
Oh, sorry.
That is a use that's only necessary because of our other proposed amendments.
Right,
Yeah.
right.
So there's no need, if we're not going to introduce new restrictions, there's no need to create a new use
Okay.
category there.
Okay, thanks for the clarification.
I also just want to clarify, just so you're aware, that currently our policy is we allow no outdoor use. So that's what will continue if we don't change our standard. So I just want you to be aware of that. We do not allow any outdoor use for business activity right now.
But it sounds like council's opposed to outdoor use anyway.
Yeah, that was one of the options, and they wanted to see both of the options move forward. So I don't know which one they would have gone with, but I just wanted you to be aware of that.
Can I ask? Technically, we don't allow it, but it's not strictly enforced. I mean, it might not be a fair question to ask at the public hearing, but.
There were 2 choices. Can you go back to that slide with the recommendations?
It's a complaint-based enforcement system based on
complaint-based
the subjective
enforcement right now.
criteria that we
Yes.
have, yeah.
And I think that's sort of, again, recognizing it's hard to enforce a complaint when the rules are written ambiguously, but I mean, I do think, and I think some of the points were made, when we're not having heavy complaints from neighbors, you know, why are we restricting the use? So
we only have these 2 options?
well, that's just on the type B restriction. There's an extra restriction for type B businesses for outdoor use, and those are the 2 options. So it's one component as part of the
Yeah,
entire.
we tried to make it easy in case you had differing, you know, ideas about this, so we presented options, but it can be modified in whichever way you can explain. As long as it's not so substantive that we'd have to renote it.
And referencing the nuisance code, I assume in there's like noise hours similar to this 9 to 7 kind of criteria than currently?
No, they were different
They
on
were
the other
different.
one.
Good evening, Bill Youngblood with the Senior Code Enforcement Specialist. So in reference to the question about noise, so So there's actually two sections. One is very broad. It says any loud or disturbing unnecessary noise is illegal noise. And we don't use decibel levels to determine illegal noise. And so then there's another section that talks about specific noise prohibitions, which goes through and does a laundry list of examples of illegal noise. But there are no time requirements in the code. There are typically after 10 p.m. and prior to 7 a.m. is a time that the police department has used, and so code enforcement has also used that as times to where if you're going to be generating a noise, you need to have a good reason why it needs to occur during that time period, and it can occur after 7 and before 10. Is that helpful? Good.
Commissioners? Yep, we can continue to deliberate as much as we want. That's certainly, I'm not trying to rush anyone. But if we don't have any other comments or questions, then we need to make a motion. I don't think the chair is allowed to make the motion. Is the chair allowed to make the motion? No.
I don't like either option,
What's that?
either of these options.
Well, again, here are our choices. We move to recommend to City Council the proposed recommendations from staff as they're currently written, all of the whole
As
thing.
presented?
As presented. I think maybe we can keep both options in the recommendation, or we pick one of the options for the agriculture type B use. I'm not sure what the proper
Correct.
procedure would be for that.
I would recommending one of the options.
One of the options, okay. So we propose recommending the staff recommendations as written and choose which option under that specific agriculture use scenario. We recommend to go to City Council with some changes. I think we're allowed to do that. Some tweaks or changes, or 3, we reject it.
Recommend
Not-
council deny.
To not approve it.
Yeah.
So those are options.
To recommend that the council not approve the staff report as presented?
Not approve this land use decision, this text amendment.
Yeah, I'm hesitant to throw like the baby out with the bathwater though, because I feel like there are a few good points in here that would be worth keeping, but reject the whole thing, but I don't want to, again, like poo-poo the work that has been done because there is some valuable stuff in here. So I don't know if we want to go through it point by point or if that's going to be a pain. Is there anything that we all agree on?
I think we should go through it point by point.
Okay.
Yeah. I think, Michael, stop me. The way I'm going to go through it is just on the sort of the recommendations, the numbered recommendations, like, and go through that point by point, because I feel like that's the easiest way to do this.
Okay, I do also have the, if you want it, I do have the code itself ready to look at, so if you want to go through it that way, you can.
Okay. Maybe we'll use that as the supplement, but these,
All 74
this
pages?
is the sum, these are like the summary of it. So 1, delete subsection 1, which states that a home occupation can't alter, the standard is unclear, right? So the first recommendation really is just delete that language. Let's come back to that, because that's really the overall point of everything. 2, recommendation is to classify home occupations into 3 types, A, B, and C, and allow the city to tailor regulations to those type of home occupations that have a larger potential impact on neighbor properties. So type A businesses would now be ones that don't bring customers to the home. Type B businesses would be ones that involve customers to the site, and which will have a few additional points here later. And then type C is short-term rentals, which currently subject to home occupation regulations with their own set of standards. So point 2 would be creating these three types.
And I'm good with that.
Yeah, I'm in favor of that as well.
Brian, Jim? I don't think
Classifications.
nobody really has a problem with creating the three standards, the three types. I think when you get into the regulation of B is really where we're going to have the disagreement. All right, number 3, add a requirement that hazardous substances beyond consumer quantities, are not allowed. While hazardous substances are regulated at the state level, adding regulation to the city's home occupation standards would make it possible to prohibit a home occupation from storing and using an amount of hazardous substance that is greater than the typical household limit.
I agree to that.
Is there any definition for what a hazardous substance is here? I mean, can we have some, if there is one, could you just?
I think it's listed in the code, right? Yeah, specifically.
Yes, there is a definition. I don't know it off the top of my head, and it's not part of the presentation, but there is a definition in our code that defines what a hazardous.
It's pretty standard throughout most cities.
Are we, when we say great, it's the proposed statute would say greater than household quantities? Like, it would say something along those lines. I know we have.
Let's go to the.
Yeah.
Yeah, so any substance listed or described as hazardous in ORS Chapter 453 is not permitted at the property where the business occurs except that consumer quantities are allowed. Consumer quantities of hazardous substances are packaged and distributed in a form intended or suitable for sale through retail sales outlets for consumption by individuals for purposes of personal care and household use.
Yeah, we can't, yeah, sorry.
Yeah, we can't.
I'm not going to say it because, sorry, there's just me here, I'm just
We,
going to say it.
we can't, I
can't take
apologize.
that.
So
Yeah,
we can't take your
Yeah,
testimony.
it's a-
I understand where you're.
It's just
This
not allowed.
definition, it doesn't cover that. You
We
don't
can't-
cover artisans for anything.
Yeah, see, I understand where he's coming from. My concern would be like, somebody developing photos, studio, through retail sales outlets. I mean, if you're doing anything and you're buying it like a wholesale quantity of something, it doesn't necessarily mean it's inherently dangerous. So this is one of those ones I feel like we're like unnecessarily pigeonholing potential businesses into a rule that, and there needs to be some sort of limits with stuff, but not, I mean, I think this is unintended consequences potentially for this one.
If we didn't adopt this right now, it's just the state code on regulation of hazardous materials that would apply? State law?
No.
Yeah, so that's a good question. I don't know that we have the answer for. Our fire department regulates storage of some like flammable materials and tries to ensure that they're safely stored. But that's the only thing I'm aware of.
And is the fire department regulating that based on state law? Since I don't think we have a regulation of hazardous materials in our city code?
Right, yes, I think so. I don't know for sure, but as you said, there's nothing in our regulations about how to regulate it.
And it does look like the definition does reference state law as well, so that would track, but it is a little bit broader as well. It
Yeah.
includes, yeah.
That's exactly my line of inquiry. Are we trying to close the gap to get like a little bit broader than state law? Like somewhere we're regulating somewhere here, if state law is up here, versus having no regulation whatsoever, which is the current regulation on a city level. Yeah, I kind of agree with Jeremy a little bit.
Answer's simple, no more than 3 months supply.
Mr. Al, please.
Thanks.
I'm going to leave because I'll tell you what, this is the problem with the survey. You didn't come to the businesses and say, come in here, we know you're doing this kind of work. Tell us what you need. And that's what.
Just have to follow procedure, I'm sorry.
Yep.
Thank you.
I'm not talking to you, I get it. I told you I'm a rule follower, but this is the problem. This right here is the problem.
Let's take a vote on this hazardous materials one, since we're going through these one by one.
Yeah, I would say no. That's my,
I
leave that one
I
out,
say
leave
no
it to
as well.
state regulations.
I say yes.
Yes. Brian? No. No? Jim? No, okay. Okay, number 4 was add a reference to the city's existing public nuisance rules to make it clear they apply. I'm on board with that. I think they do apply already, and we're just making it clear. Anybody have an opposition to that?
No.
Okay, the one vehicle at a time, requirement that only one vehicle but with visible company or commercial markings is allowed to be parked within 300 feet of the property where the home occupation is located. As you know, we recently eliminated all off-street parking requirements as an effort to comply with the CFEC program, so the city is limited in its ability to regulate. I think, if I recall, when we discussed this one at a few work sessions, and I think that's the way it's written, a individual or a business with home occupation is allowed to park as many commercial vehicles as they want on their property. There's no regulation against that. This is limiting parking off the street to one. And I think some of the examples we may have talked about was like a shift, like the beginning of the shift, like 10 trucks come in and park, and then they dole out their assignments, and then they go. I think that might have been one of the exhibits. So.
You know, the problem I have with these fine-tuning restrictions is that I can't tell whether or not this is a problem or not, or is it one that's a foreseeable problem or not, and if there's, what's the evidence? We're just kind of looking at these things generally speaking. And when we get to the point where we're trying to adjust people and their things without any kind of description of what is really at stake here, I can't make anything out of any of these fine-tuned restrictions.
Mm-hmm.
That's my problem.
Yeah. Yeah, I'd say, I mean, I think it's hard to fine-tune because you can never estimate all of the unintended consequences of any action you take, right? And on the flip side, you know, code enforcement has given testimony that it is very difficult to enforce code when it's written so ambiguously. But I'm obviously I lean in your camp, and that's why from my opinion, that's why I prompted my questions in the very beginning, which was nobody came in favor of doing this. There was no testimony from the public saying, yeah, we got, you know, businesses running wild in residential properties. They're parking 50 commercial vehicles on the street, and it's a problem, right? It was hard to understand really the justification for getting so detailed in the way we're regulating it without having all of this. I would have liked to have people who have complained about the neighbor running a gym class outside with 10, I would have liked that neighbor to come to this hearing and be like, I support this, let me give you the testimony as to why having exercise classes outside at 8 a.m. has been a problem for me, right? And so absent of that, it's really hard for me to be particular whether we should have one commercial vehicle or 3. I don't want to get into that. It's hard, in my personal opinion. I'm going to get off my soapbox because I've been talking.
No, I just want to continue to remind folks that the existing system is a lot more like all-encompassing than what we're proposing. So it's a subjective criteria that's complaint-based enforcement. What we're proposing is potentially more flexible, particularly with outdoor activity, for instance. So we're not going into add a bunch of restrictions that don't exist. We're just kind of explaining them and enumerating them here. So I want to make it clear, we're not here to like clamping down and tighten down the restrictions. We're here to just make them more clear and understandable. So I think that's probably why you didn't get that testimony, because it's not really, the intent of the project is not to clamp down and sort of enforce neighborhood character more strictly.
It sounds like that's how it's coming across to the business community, though. At least the general.
Yeah, I think there's some understanding that, about the current regulations, that when you actually spell them out and write them down on paper, people start, having a lot more thoughts and opinions on what should or should not be allowed. Of
Right.
course, they're not aware of all the things that happen, and the folks that do receive, sort of complaints or, potentially, issue fines or something like that for enforcement, they don't see that necessarily and how difficult it can be, particularly in like a court case, to actually make an argument about what has happened, and whether or not that is within our standards or not within our standards, and how that should sort of play out. So this is really about the functionality of that clear and object, or that sort of non-clear and objective standard, being able to actually enforce it with more than just kind of our extremely kind and helpful code enforcement officer and his expertise and precedent experience. So I think we're trying to, sort of start to write this down on paper as opposed to just kind of deferring to folks for sort of a subjective interpretation that then has to go to court or has to be justified further and further and further. And that's where we've run into issues.
So Eric, currently, you can't park commercial vehicles on the street?
No, that's not what I said, but I think that there could be, but I don't know, I guess code enforcement officer Youngblood, has there been any violations related to cars parked in the street related to a home occupation?
No violations, because it's not.
There's no code
well,
to violate.
But I mean, it's captured within that neighborhood character, sort of.
But I would like to say also that, the first step in looking at this was, the code enforcement staff sat down with these guys and said, here are issues that people complain about repeatedly as part of a home occupation. So they're not, they just didn't get pulled out of thin air. They're tied to complaints that we receive. Now, it's not a whole lot of complaints, it's a handful of complaints. But when these do go sideways, it's a tremendous disruption to the neighborhood, and there is not a good method currently to do enforcement on them.
So in the absence of code, you have a complaint. What's the process? They take it to you, and then what do you do with it?
Well, we look for evidence that, because we have to find a code that they're not complying with, correct? So the code that we have for home occupations, because it's typically noise complaints, okay, but it's not a complaint. The noise complaint that they have is during the day, so it's not something that typically qualifies as a nuisance noise complaint. It has to do with the business that's occurring at the house and typically outside. It typically oftentimes involves lots that are flag lots, so there may be 3 or 4 backyards that back up to this one business's backyard. I understand that it's very difficult to write something that applies to all of these different conditions that we have across the city. And it's, code enforcement staff certainly support what's before you today, but mostly for the reason that it's something that we can, find evidence that yes, they comply with this, or no, they don't comply. So it's not the number itself, it's just having a number that we have, we put out there, or that is in the code that says, this is acceptable, this is not.
It doesn't sound just like an arbitrary decision on your part. It's an actual code that you can go back to.
Well, trying to present evidence to a judge that the, neighborhood, I forget the words, but it's not a compatible, the use is not compatible with the neighborhood.
Right.
You need us to start with something, okay, so what is compatible, okay? We don't have a definition for those. So one of the things we encourage folks to do is, to get this resolved, certainly if it goes to court, is to come in and testify, right? So the judge needs to hear it from different folks, not just from myself or my coworker.
Thank you.
Thank you, Mr. Youngblood. Eric, it seems to me, when you say this is just like clarifying restrictions that are already in place, like I don't see it that way personally. And I use the commercial parking example. There's no prohibition on parking now, except if it changes the alteration of the residential neighborhood of the character, right? But right now, if you had 3 commercial vehicles on a street and nobody complained, that wouldn't be restricted, right? And what we're proposing right now is a 1 commercial vehicle cap on parking on the street. So that is more restrictive than it currently is. And I think the other one is for type B businesses, eight clients on the premises at a time, I think is one of them, Michael? Right now, there's no prohibition on the number, right? Correct? On a home occupation inside on the limited amount of clients?
Yes, that's correct.
Correct.
No prohibition.
So the proposal of 8 limit is more restrictive, right? So I understand it's not, there are a lot of restrictions that are in place that are just not, are hard to enforce, but they're there. But I do think this is more restrictive than the current practice.
Yeah, I guess my point is just that, those things, again, we've spent a lot of staff time on this. That's really my concern. We're trying to develop a proposal that makes sense and can be enforced. And we've spent a lot of time trying to talk about what is the appropriate level of how many cars should be parked, how many, how many clients, et cetera, those limitations. So if you're concerned about where we're landing with those, we could adjust those numbers, those figures. More commercial vehicles should be allowed to be parked off the property. Maybe we just don't limit commercial vehicles. That's fine. I mean, I think we can make those changes, but I just want to point out that reverting to our existing standard might not necessarily, I do think that there are elements here where we actually are enumerating, sort of exactly what the city does. We've tried to define those. It can be difficult in terms of what is and is not enforced, but if we're not landing on exactly where we need to land, that can be adjusted. I just kind of wanted to point that out. And I think, again, maybe this is too limiting. So if that's the case, then would you limit it less? Or do you think it's just better to go with that subjective criteria? I think that's kind of the question here.
Sure.
So, we're trying to land at a reasonable place. I think in some ways it is actually a lot more, it does offer more flexibility, particularly for outdoor businesses. There's some other ones where I guess we probably landed a little bit differently, but we're trying to triangulate here. So we're open to suggestions, and we've been trying to get them from folks, and it's really hard to dial in on a specific number, as we've all noted.
Yeah. I appreciate that, and to the extent I made it feel like we weren't appreciative of that, apologies. I mean, I think, and again, I think we've had our work sessions where we've sort of been like, we don't really know what the reasonable number should be. But I believe city council in their hearings are saying be more restrictive, right? So I think staff has been put in that position. You ultimately have to carry out what we think city council is going to recommend, right? So I guess my question for you, is it better, is city council going to, if we say our recommendation is the city council not to recommend as written, but city council says, this is great, thank you staff, this is exactly what we wanted, we're going to disregard the planning commission and we're going to vote it, should that happen? Maybe that's what should happen. Instead of us going back on trying to find a middle ground on limitations that we all feel uneasy about.
Well, I mean, the council, the reason why we have the planning commission, right, is that you all are doing this great work and making recommendations to the council that, and you kind of dive more deeply into it before it comes to the council in general. So I think that if you are going to make a different recommendation to the council, you can do that. I mean, you're allowed to do that as a body, and you can specify why you believe that this is the right recommendation, and the council will consider that. And ultimately, it is their decision, and they may or may not agree with you all, but it's your recommendation. We're simply telling you what the feedback is that we received from them, and they did land more restrictive than this commission did previously.
Yeah, I think, obviously an outright rejection, or just recommending disapproval, you might not have as much of a voice to say, well, if you do, we really think that this standard is important and you should adjust the standard, et cetera. You could have a little bit more of a voice on the changes that you think are appropriate if you did make a recommendation of some type to approve, but it's, of course, up to you. But that's just kind of, in the way that this is an advisory body, if that is the recommendation, there might be a little bit more, there could be eventual agreement if you took that approach, potentially. Or at least it would land a little bit closer to the middle, I guess, is more what I'm trying to say.
I think for me, you know, if you're living in a society that's run amok, then you can step in and supervise people to make clear what you won't endure. But I don't have that feeling about this city, to the point where I feel as though we ought to supervise this down to, you know, a fine-tooth comb. I just don't see it.
I'll just sum up my thoughts. Of this 1 through 8 here, I'm concerned about 3 and 6, the possible unintended consequences on traded sector, small businesses, entrepreneurs, stuff like that. And then kind of with that, number 7, you know, I would support like number 7, option 1, because I wouldn't, in the same concern for small business and entrepreneurs, I wouldn't want a blanket outdoor ban on outdoor activity, yoga classes, stuff like that, in the absence of 0 complaints or concerns that have come before this group. And I haven't been present for the previous work session, so acknowledging that as well, but that's my thoughts.
Right.
I guess I would just add, I'm not sure council's alignment is in alignment on this either, so, you know, your recommendation might sway some folks.
Yeah, I agree. The only thing I might disagree with is the outdoor one. I'd honestly prefer a blanket outdoor one, just because you start setting limits on who and what and when and how many, and I think it's just easier to say no for everybody. They're more likely, I feel like outdoor activities are more likely to impact neighbors and surrounding properties as well. If you have a home business, you can do your activities inside your home. That's different. I just think it opens a big can of things potentially. So it'd be easier just to have a blanket no. And we have the blanket no currently, so it's not like it's going to impact anything new by changing it.
Yeah, it was the opposite. I was like, a 10-person yoga class on a Sunday is like, what are we regulating that for? I keep going back to the nuisance and the nuisance code, which is outside our purview, but like, can what we're trying to achieve, which is loud, noisy, harmful, impacting neighboring properties, can that be achieved by altering the nuisance code, which is not our purview? And that's a whole different can of worms that I'm not suggesting we open up, but that's where I keep going back to.
I'd still stick with the outdoor no. You're going to have those traffic from the people. You're going to have those cars from that. You know, if I'm in my backyard, I don't want to listen to Namaste, and I don't care if it's a yoga class or if it's a Pilates class or whatever. I feel outdoors, it's just too much can go on, but that's just my thought.
Yeah. Thanks, Chairman. Do we want to keep going through individually? I mean, I think, well, we did, that was sort of 7, right?
We're almost done, although it sounds like it may be a waste of time for us to be doing this anyway, so.
I think the question really for Michael, like, is it better for us to try to reach, to your point, like, if we're regulating but we don't feel comfortable with where we're landing, to try to adjust and have a recommendation to city council? And to your point, like, that gives us a seat, like our voice is heard, maybe a little bit more as opposed to just a blanket we don't recommend? Or is it just better now for us to say that we're so misaligned on everything, like let's recommend to not approve and let the city council decide?
That we feel it's too restrictive on businesses.
I mean, that's a totally reasonable recommendation to make. I wouldn't say otherwise. If somebody felt strongly about like the 10-person maximum or whatever, you wouldn't necessarily be able to weigh in on those specifics if you just recommended disapproval. But again, that might not be, the hill you want to die on, or that's a terrible metaphor. But anyway, it's a strategy decision on your part. Or we could try to develop something that is more like what you are looking for and bring that back to you and delay this even further. So yeah, it's up to you. You know, again, we're trying to triangulate between council, planning commission, sort of code enforcement needs to land on a happy medium here. So if more work is needed, then that's something we can consider as well.
I like that recommendation, that we work on this a little, massage it a little more.
It seems like that might be difficult to accomplish this evening.
Yeah,
Yeah.
we can just continue it.
Yeah,
I know it's more work for you, sorry.
yeah, exactly. I feel bad
I guess
about
probably what we
creating
do
more
is
work.
like withdraw this application and then resubmit an application in the future. Or something.
Or we could just continue the hearing.
Yeah, but we would have to renotice if we were to change it substantively, I guess, and we'd want to know kind of where you want to go. So yes, we could obviously continue the hearing, but you would have to decide, without the benefit of like a work session or something like that in between. So you'd have to make up your mind at the date of that continued hearing. So. But, there's no timeline for this, I guess is my point. Like, there's no due date, there's no state mandate. So we're doing this based on council direction, and it's not like a council goal necessarily. It's something that we are, fulfilling based on what we've been told to do from them, but there's no huge priority to get this done right away.
Well, I mean, that may be a good thing. In this way, this would give more businesses the opportunity to come in and, speak their piece. And maybe we can take our direction from there and include those in our recommendations. It's just getting people here. I was excited to finally see people here.
And I think
You must have missed the last hearing.
yeah, the last.
I wasn't here.
The surveys were, again, I'm not a home business in Lake Oswego, so I'd say this with like a grain of salt, or a huge grain of salt. The surveys were pretty comprehensive, and we got results, and like I read the results, right? So I do feel the public was given the chance to opine, or the businesses were given a chance to opine based on surveys. Again, yes, I wish more people had come here and been like, yes, I've been complaining about my neighbor's doing this on their property, and here's my chance to really show my support for this proposed code amendment. So,
I mean, where's the Chamber of Commerce? They should be here.
Well, again, the idea is not to clamp down and make it harder to do home occupations. So I think, if it is about where we're landing and you think that where we're landing doesn't reflect actual use patterns, and maybe we need to go back and talk to home-based occupation owners to get a better understanding of their needs and make sure that we're not going to restrict them. I don't know what that looks like, but, it wouldn't happen immediately. I'll just put it that way if we are going to revisit this.
let's make the hard decision. Do we think that there is some compromise that bad word, but compromise that we as commissioners can get to where we would vote a recommendation to approve? And those things would look like, instead of prohibiting more than one commercial vehicle, are we saying 5 commercial vehicles, right? Like, if we're a lot, or 8 people at a time in the in-home business versus, make it 20, right? If we all decide like we can be comfortable with some number, we just think it's too restrictive at this point, then I think it's worth that. If we are, and maybe Jim, I don't want to speak for you, but if we are like philosophically like, I don't want to impose restrictions right now, again, there might already be there, but I don't want to do any of this, then that's a different conversation. And then it's not worth, in my opinion, like coming back.
Well, I could go with that if you brought some evidence in here, that demanded action. We haven't heard anything like that. That's the problem for me.
Well, except for a couple of people tonight.
Well, I think he's talking about the opposite direction.
More restrictive.
Yeah.
Oh, more restrictive on the other side, okay.
Yeah, I don't want to come back and argue about 3 vehicles versus 5 vehicles, or I don't feel like I'm qualified to say that 3 is good or 1 is good or whatever. I mean, if we had to make a simple notion, it would be that we would, approve limited approval of some of these things and then not approve some of the restrictive ones, but I don't know if that's an option. I mean, I don't want to make code enforcement's job more difficult. Some of it needs to be refined, but I don't think we're the body that needs to put hard limits on these things.
So I can propose a motion to advance this, but striking 3, 5, and 6. Still have to come to some consensus on option 1 or option 2 for number 7.
Striking 3, 5, and 6, and then coming to a consensus on 7. Oh, we didn't talk about 8, by the way. Childcare homes and adult foster homes are exempt from the regulations under state law.
Yeah,
I think it's just clarifying
yeah, it's
that.
clarifying.
Nobody has a problem with that, right? Okay. So striking 3, 5, and 6, and then us making a decision on 7.
So 7, I'm opposed to outdoor, you're pro, what is the rest of the council?
Pro outdoor.
You're pro outdoor, okay.
That would make me 7-1.
7A,
7A.
and then 8, of course, is.
Structurally.
I second. Oh, didn't you just make a motion?
Oh, but I didn't.
I think we're just
Oh.
talking about the
Oh,
motion. Yeah,
sorry.
Yeah. So it's striking 3, 5, and 6, and then you want to decide 7,
Right.
1?
7,
option
1,
one.
7.
7A1. And you're for 7A2?
Mm-hmm.
But you also would be on board with something striking 3, 5, and 6?
Absolutely, yep.
3. Actually, I'm okay with 3.
Well, you're just complicating it.
Well, because the fire department already does a lot. And there's state regulations that people need to follow. And so businesses, and that's what I do. I'm the director of a small business development center. And so I work with this all the time. People that start a business from their home, they understand what they can and cannot do. And in order for them to get a business license, there are certain requirements they have to meet. So they already know.
That's why I propose to strike 3, for exactly what you're saying.
Well, and so like this gentleman was saying today, it's like you're not taking into consideration all of these other exceptions. So,
But that would be
because,
in favor of striking 3, no? Because 3, we have, striking 3 means it's state law, and that, like, it's clear, it's state law, that's what we're
right,
doing.
you're right.
And we're not adding a
Okay,
little bit more.
you're right.
We're all saying the same thing.
Yes.
And which one were you for option 7? Option
7A.
1? 7A.
1.
Jim? Jim, what are you thinking? With striking 3, what was it again? 3, 5, and 6, and then on 7, Jim, with outdoor, there's an option 1, which is there is some, we allow it, but we regulate people, the amount of people and the times, or B, an outright ban on outdoor activity tied to a home occupation.
You know, when you're adjusting these different categories, the thing that comes to mind to me is that the elements of due process of law mean that people know and have been given an opportunity to comply, and if they don't, then they know the consequences of that. Many of these things that we have talked about tonight, and this is the last category that you're talking about, is the same sort of situation, and I just don't see why this is helpful. I don't see how this in any way, shape, or form is going to notify and give the average person an understanding of what's going on here. Because we haven't heard any evidence of, gross areas of misconduct in these various categories that we're looking at here.
So because 7B bans all outdoor activity outright, and so it sounds like you're for 7A1, which would be less regulation on outdoor activity?
Or it would be allowed, basically. A allows it and B doesn't allow it.
I think you have to allow something. I don't see any reason to negate some activity here unless, like, say again, bring me some evidence to show why that is needed. We went through this in April. We went through the same kind of thing when we came through it. And it was
Yeah.
just about as vague then as it is now. And I haven't seen, when I left here, I thought, are we trying to adjust people in every aspect of their lives so that there's no conduct left for them to decide upon themselves whether they're reasonable or not?
And in option one, it says six, the staff report says limited to 6 clients. Was that changed to 10? Can you run us through that, Michael? Like, what is the?
Yes, so when we discussed it in June, I think we were proposing the same as inside, so 8. And when we discussed it with the council in October, they felt that that would have too much of an impact if it was part of regular business activities. And so they suggested that we adjust it down. They didn't give us the specific number of 6, but that was kind of where we landed based on their feedback.
And then the agricultural use is entirely separate, and as drafted right now, that's 10.
Yes,
And then all the other requirements, like greater than an acre, but 10.
correct.
And we have one written testimony from a winery that provides testimony that said they would prefer it to be 30.
Yes.
And then the question on grandfathering, and I know we talked about it, but can you clarify? Would that winery be grandfathered if it in fact came out as 10?
So it would be grandfathered from having to get a conditional use, but it would still have to comply with the new requirements.
So they would be limited at 10. We haven't talked about the agricultural use one either, to be honest. I mean, we have, not in our listing right here, so. So we have delete.
5 and 7.
These two are on the same page. Jeremy's on the same page except for 7. He's on option 2. Jim, I think you're coming down as like no recommendation. I don't want to speak for you.
Well, I would say option 1 as opposed to option 2.
If you had to pick, you would pick option 1.
Make a proposal and I'll get on board.
What's that?
I said, make a proposal and I'll get on board. This is not the outdoor activities, not the hill I want to die on either. I mean,
Well, I think you can.
my only comment would be is like the same thing with anything else. The 6 seems arbitrary. I don't know where they came up with that number, but, or there's 2 sessions a day and 6 per week. I mean, all of it seems arbitrary, right? That's why no seems easier, but since it's currently no, but if someone, will vote for yay to eliminate the other options.
The number comes from the complaints,
There's no outdoor activity currently allowed.
but from the complaints that code enforcement has received from
But then
outdoor activity that has no code to cover it.
But that should be easy. There's no outdoor activity allowed. So
Right.
that should be easy to enforce.
Right, which is why we're having these conversations, because there was nothing in place, and now they want something in place. So
But I'm not
you
understanding
want,
what you're saying. If
you
there's
want
outdoor-
code because there really is nothing to fall back on if there is a complaint.
Clarify that outdoor activity in connection with a home occupation business is technically prohibited right now. Is that correct?
Yes, because of the city manager. So if you look at our code, otherwise, it does allow outdoor activity, but there was no limit on what you could do. And we had, folks that were renting out their swimming pools through an app and having, 30, 40 kids come over at a time, multiple times a week. So that's really what drove the the moratorium, if that's the right word.
Oh, so currently in place, the prohibition is a city manager moratorium? Like,
Yeah, it's a
Policy.
staff policy, yeah, it's more or less, yeah.
Because there is nothing in
That's
place.
how it's been interpreted because
okay.
That's
of
what I
the
mean.
Oh, that's-
subjective
I
standard.
misunderstood. I
Executive
thought that
power.
was a policy.
The code is so open-ended,
Okay.
and so we made an interpretation that it disturbs the, again, why can't I?
A residential character of the
Yeah,
neighborhood.
there you
Yeah.
go. To have an outdoor activity, that's the current interpretation and our policy. But it's not stated in code, so that's the thing, is that the public doesn't understand that.
Okay, that being clarified, I could get more on board with option one. I thought it was already blanket banned. I didn't realize that they arbitrarily banned it, so.
Do we want to touch what we're calling option 10 right now, the urban agriculture
sure,
limits on?
yeah.
I'm uncomfortable with this 30, 10, back to 30 for this particular business that doesn't have any complaints against it.
What's the solution? Is the solution to move it to 30? Is the solution to move it to 50? Is the solution to
Not have a limit.
not have a limit?
I have a recommendation, if you don't mind,
Of
Chair.
course, yeah, please.
So one of the things that you could, this is a conditional use. So someone has to get a conditional use permit in order to have this as an accessory use. And you could say that the maximum number of clients are established as part of the conditional use permit. And that way the applicant can provide evidence. I can accommodate
Space,
20,
parking.
I could accommodate 40, I could accommodate whatever that is, based on, again, it can be open-ended what those parameters are. I have X number of parking spaces, I can do a shuttle, whatever it is that they can do. And then that way you can be more flexible without coming up with a number, but you're going through this discretionary process that allows people to submit testimony, they can submit their evidence, and then ultimately the permit, they can decide based on the evidence in the record what is appropriate for that site and that particular use.
I like that. I don't know about Eric's questioning face. What are you wondering?
I was just thinking about, we're wanting to create some more clear and objective standards through this exercise. If we have more flexibility, I was just thinking, going through the internal process of thinking, this is a conditional permit anyway, so that's probably okay. It's my thinking face, I guess. It's not supposed to be a clear and objective, like, this is what you got to do thing. It's more conditional.
Right.
Here's what I would do if I were not chair. I would make, it sounds like there's a consensus for at least 3 on a path, and I would make a motion for it, and then let the other 2 decide how they want. Because if we have 3, it passes, right? 3 out of 3. So to get us all out of here, I would do that if I were allowed to.
Okay, Mr. Chair, I'll make a motion to propose this as written, but striking 3, 5, 6, and recommending 7A, option 1.
And then
The
limit
urban.
on agricultural use,
To conditional use permits.
decide in the conditional use permit. That, I know, we said that inartfully, but everyone got what we meant, right?
I second that.
Okay, let's take a vote. Christina?
King Mitchell,
No.
Moreno,
Yes.
Kinney,
Yes.
Sly,
Yes.
Ewing,
Yes.
and carries.
No.
Passes 4-1. We go back to we're way off script here. So it said passes and commissioners discuss, motion, called the roll, okay? I think the city attorney is supposed to state that this is a tentative decision of the PC, and we'll state the date. I don't know.
Yes, I can state that. So
Thanks.
the vote was only a preliminary decision concerning the commission's recommendation. The final decision on the recommendation will be made upon the adoption of a written order on December 8th, 2025 at 6:30. This recommendation will be forwarded to the city council for review.
Thank you. And thank you, commissioners, for like really thoughtful discussion. And staff, thank you for taking us through this. This has been a long journey. And, you know, speaking on behalf of myself, honestly, it was like, you did a wonderful job. And my holes were nothing to do with the way you compiled and brought the information to us, for me.
Thank you.
Okay. Well, I'm sure everyone wants to go home. Item number 6, other business. Do we have any other business? Item number 7, schedule review.
All right, so coming up at our next meeting, as we just mentioned, you know, we will have the consideration of findings to, you know, move forward your recommendation to the city council based on tonight's hearing. So for the home occupation standards, we'll have the findings. We'll have a work session from Ms. Monalu here on our proposed regulations, our proposed amendments to our tree regulations, so really about our tree regulation work. And we'll also have the continued hearing for 4,000 Cruiseway Place, which you've been receiving some correspondence here and there with some additional testimony from the public, as well as you know, the applicant's final argument, et cetera. So you'll also be receiving a staff report on that, but you know, that officially the hearing was continued until the 8th of December on that. So you know, you've been receiving some correspondence on that, so hopefully that's not a surprise. So yeah, that's all we have for December. We don't meet twice in December, so our next meetings would be in January. You know, ideally at that point, we'd be in a position to adopt findings for 4,000 Cruiseway Place, as well as you'll be receiving a presentation from myself and our consultant team for the Foothills plan update work, and we'll be talking specifically about opportunities and constraints in the area, and just talking about kind of existing conditions and all of the interesting details about the work that we're doing over there, and what's there really currently right now, and what we can capitalize upon, and what some constraints are that exist. So we'll get into a little bit more discussion of that on the 12th of January, our first meeting there. And then on the 26th, all we have scheduled for that right now is a work plan review. So just talking about our proposed work plan as a planning commission for 2026 to help fulfill city council goals. And that brings us through January.
Great. Thank you, Eric. And I'll plug, I would recommend to the commissioners, let's read the findings for this hearing ahead of time so that when we get here on the 8th, they're going to be here on the 8th, I think, everyone's comfortable with the changes, because there was a lot, it was kind of dense, the conversation, so there should be some changes. So let's try to, because there's a lot on the agenda for the 8th, so let's try to come prepared to say thank you. Okay, I think that's it. Adjourned.